All right, so good afternoon, everybody, and welcome to the month of February 2025. It has already been a busy, busy time in many ways. For those of you who follow, you know I went up for the inauguration week and we had many meetings and had some new people joining us to learn how to tell their story to Congress and help us move into family advocacy. Then I went back this week because Robert F. Kennedy had confirmation hearings. I think he's a very important part of what we need to happen, although they don't really talk about CPS much. They talk about everything that surrounds it. So hopefully that will be helpful to us. So we're going to dig right into the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. This is a little bit hard. All the topics that I have picked, when I first look at them, having had 30 years in practice, they all look a little overwhelming because I just have been swimming in this for so long. It's like evidence and preparing witnesses and authentication of documents. You have to understand that since I've been in these for so long, I see like this whole massive picture, and it takes me a while to digest it and try to figure out how to spew that back out. So there are going to be parts of this that overlap. I did an outline, and then I'm going to pull up specifically a couple of the official documents of the government because, as you know, as advocates, we will always be challenged as to the source of our information. So let's just dig right into it, and there will be some follow-up on this on some more specifics. But the Title II of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act. When you finish with your ADA training, hold on here. I'm sorry, you three people. Okay, hang on. I need to let some people in. Just give me a second. So when you finish this training on the ADA, you should understand, you should know what it is, what are these two laws, why does it matter, how does it apply, and what should a parent or advocate do when they believe that the ADA may be beneficial to their case. So understanding ADA and Section 504 in CPS cases. So introduction, again, the purpose of the training is you have got to be able to use ADA as an advocate or in your own case if you're still involved in litigation with CPS. We're going to kind of overview ADA in Section 504 and continue to just kind of tear it apart. And understand the importance of knowing these laws for parents and advocates. Um, so we're going to look at the definition and scope of ADA. So the Americans with Disabilities Act is a federal law, and it has four titles. A lot of times already in CPS, you hear us talking about Title 4E, Title 4B. I know it gets very, very confusing, but basically what you have is under the U.S. Code, there are large sections, and then under each section, there are titles, and then there are subsections of that. So when we look at ADA, there are four main titles. The first one has to do with employment. Title II is public services. Title III is public accommodations. And Title IV is telecommunications. So just generally under Title I, it means that if somebody is employed and they have a disability, they can request accommodations to be able to fulfill their employment obligations. Title III, public accommodations, has to do with like hotels, bus stations, etc. Title IV, telecommunications, has to do with providing special instrumentation for people who, for instance, are deaf. Title II is the main one that we're going to talk about. It says public services. It applies to all state and local government services. And so that's what I want to ring in your head over and over and over and over, is that we are talking about title. And if you aren't muted, if you would just double check and mute. So I would appreciate it. So when we talk about ADA, we're going to be talking Title II, Title II, Title II. I don't want you to ever confuse that with Title IV-E, Title IV-B, Title X, some of the other things that we're going to continue to talk about as we learn advocacy. But the ADA, Title II, is where we're going to fall with CPS. The key provisions relevant to child protective services. You will need to understand what the definition of a disability is and reasonable accommodations. Those are the two key elements. And I want to tell you right now, these are affirmative requests. So if you are a parent or you're an advocate, you have to affirmatively seek relief under ADA. They're not going to jump out there and give it to you. That's the one kind of weakness with ADA is that people don't quite understand. Maybe they have a disability, and particularly in child welfare cases, this has been so totally ignored that, even though parents are criticized for having not being able to take care of their children because of some silent disability, they are also not provided ADA relief. Now, there is in the brochures that they hand out, and I think there's something called a Client's Right Handbook. There's this little tiny, tiny print on one page, which is about 2 sentences that talks about the ADA, but it really isn't sufficient to give parents notice. So we're going to talk more about what is a disability and what are reasonable accommodations, and then the importance of ADA in protecting the rights of individuals with disabilities. All right, so the overview, and somebody still needs to mute out. If you would check that for me, please. The overview of the Rehabilitation Act, Section 504. What is the definition of purpose of Section 504? What are the key provisions? Which means that there is non-discrimination in programs receiving federal funding and the right to accommodations and accessibility, and there is an intersection with ADA. Now, the two things are a little bit different because when you look at where they apply, that's kind of, although there's a difference in it, you're going to find that there are similar applications. So ADA says under public services, all services provided by state and local government, but it does not provide for federal agencies and federal courts, right? It is for state and local public services. However, under Section 504, it's a little bit different because it talks about non-discrimination in programs receiving federal funding. So there may be times, of course, we know that the CPS organizations receive federal funding, but there may be times when we need to shift over to Section 504 to protect some parental rights where they may not be protected directly under ADA. All right, the application to CPS. How does ADA and Section 504 affect CPS proceedings? What are the rights of parents and children with disabilities? The obligations of CPS to provide accommodations, some examples of reasonable accommodations, communication, access, interpreters, etc., modified meeting environments, and legal precedents and case studies you're going to hear about today as we get further into it. Also, how to seek relief and advocate, how parents and advocates can assert their rights, understanding the complaint process, filing complaints with appropriate agencies. In other words, what do you do if they don't do it? Or what do you do if they don't comply? Or what do you do if they totally ignore you? And then what are the resources available for support? Are there legal aid organizations, disability groups, etc., or just advocates who know how to help put together complaints? Now, building partnerships with legal and community advocates as well. Of course, that's what we want is the advocacy program that will support people who need these accommodations and will be articulate enough in knowing how to ask for them or helping the parent ask for them. The best practices for parents and advocates, documenting interactions and accommodations needed, effective communication and strategies with CPS, and building a support network. And then as we conclude, we'll try to recap some of the key points, and we will try to take a few questions and answers. And then there are a couple resources that I'm going to provide links to. And then, of course, you all have my contact information. And ultimately, I'm going to create a one-pager fact sheet and checklist for protecting ADA and Section 504 rights. All right, there are a couple of important government online resources. One of them is Rights of Parents with Disabilities, which is found under the ada.gov. So you can see right here, it's a pretty simple website, and I think I found it just by Googling it, but it's ada.gov/topics/parental-rights/. We're going to take a look at it in just a second. The other one is Technical Assistance for Aiding Parents with Disabilities, which is actually a subsection of the first link, but it is an ADA archive, and it was in connection with the DOJ. And I'm going to take a look at those for a minute, and then we're going to come back to the outline, and then we'll come back and address some questions we found in there, and I'll provide these links. All right, so let's look at, first of all, the ada.gov website. So this is, again, just ada.gov, where everybody has access to it. There's a particular page for the rights of parents with disabilities. And you also notice right here, this is very, very, very important. There is the ability to file a complaint with ada.gov with the Department of Justice right here in the Civil Rights Division. You've got a link to it right here on this page. And this says that state and local child welfare agencies, as well as courts, are responsible for protecting children and families, but they also need to ensure that as a parent, guardian, or prospective parent with a disability, you are not discriminated against based on a disability. By doing so, courts and agencies not only will be helping to place your children in safe caring homes, but they will also be complying with ADA. So there are a couple other guides here as you get to this page, and I will try to put these links. I think I can put them in the classroom, but there's a guidance and resource material, and then there's also information about the legal requirements. Again, ADA is not going to be just one training session here. We're going to go back over it and dig into it deeper so that you are very conversant on it and can talk about it. Examples of child welfare services. So child welfare agencies and courts need to make sure that they provide their services in ways that do not discriminate against parents with disabilities. Importantly, an agency or a court may not rely on stereotypes about individuals with disabilities. Imagine that. And in many instances, they must make reasonable changes in the way they usually do things so that people with disabilities can fully participate. All services offered by child welfare agencies and courts need to comply with ADA, including, for example, pay attention. When a caseworker comes to your home and investigates a report of child abuse or neglect, when a child welfare agency evaluates your fitness as a parent, when you ask for in-home services to help you care for or reunite with your child, when you are being considered for visitation, guardianship, adoption, or foster care, when you are in court participating in a hearing about custody or the possible termination of your parental rights. Okay, so these are some very good examples in here from the very first time. And this is why people need to understand, because there may be, as you'll see as we go through this, some silent injuries or some exaggerated anxiety that creates this disability within the parent that is sometimes even situational. All right, individualized treatment for parents. When making important decisions regarding parent or prospective parent with a disability, a child welfare agency or court must conduct an individualized assessment. That's a key word here. If you're taking notes today, write that down. Individualized assessment of the parent's ability to provide for the child's need well-being, and welfare. This is not your standard checklist. This means that you need to look at any individualized need that the parent has that needs to be receive accommodations. This means they must make a fair determination as to the parent's ability to care for a child, assess the parent on an individual basis, and they must not rely on stereotypes about people with disabilities and how they parent. So important. Examples of how child welfare agencies and court can provide equal access. There are different actions that a child welfare agency or court generally must take to ensure that they are providing parents, guardians, and prospective parents with disabilities a full and equal opportunity to participate in and benefit from the agency's programs and services. Again, the key word here is that they must take, they must ensure that they are providing parents and guardians with the full and equal opportunity to participate. For example, a child welfare agency or court generally must provide an interpreter at a court hearing for a father who is deaf and uses sign language, provide large print, electronically accessible adoption materials for a prospective parent who is interested in adoption and has a vision disability. And then there is some additional information on that link of communicating effectively. And then you can see there are other links here as well. The agency or court may also need to provide hands-on or individualized instruction to a mother with intellectual disabilities so she can participate in parenting classes that are ordinarily provided in a group or classroom format, arrange for available services beyond what the agency would normally provide. For example, help with housing needs, counseling, parenting classes, as reasonable modifications to its procedures and practices. And then it talks about there are additional ways to learn and other examples. In addition, the child welfare agency or court may not require a person with a disability to bring their own interpreter, rely on a minor child or family member to interpret, to rely on an adult family member to interpret, or charge a person with a disability for any cost associated with providing effective communication. All right, now I'm going to move over to this other document called Protecting Parents and Prospective Parents with Disabilities, Technical Assistance for State and Local Child Welfare Agencies and Courts under Title II of the Americans with Disabilities Act and Section 4 of the Rehabilitation Act. Now, I'm going to tell you that this came out of an investigation in 2015. I was very excited to see when this investigation came forward. This was out of Massachusetts. There was a young mother with a mental disability, basically a learning disability, and she had a baby, and the maternal grandmother stepped up and said that she would help her daughter parent her child, and she agreed to be a placement. And the Massachusetts CPS said, no, that's not appropriate. We're going to take the child. And maybe by filing complaints online, they were able to engage the Department of Justice and HHS into an investigation, and they found out and they made a ruling that the Massachusetts CPS agency had violated ADA for this mother in that working with her own mother, the maternal grandmother, was a reasonable accommodations for her to be able to safely parent. Now, this document is pretty long, and I'm going to go back to our main outline. And if we have time today, I will come back to it. But otherwise, we will set this up as an additional training day. All right, so recognizing somebody, I can't see everybody because you're in a little column here on the side. So please check and see if you have your microphone muted. I appreciate it. And I can see you all are here, and I appreciate your company here. It always makes for a more enthusiastic training session. Recognizable and silent disabilities under the ADA. So, recognizable disabilities are disabilities that are often visible or easily identifiable, but they still may carry significant implications that require accommodations, such as TBI, traumatic brain injury. It is an injury to the brain caused by an external force, such as a fall or accident. It can result in cognitive impairments, difficulties with memory, attention, and emotional regulations. Certain accommodations may be extended time for task, modified workloads, or support for cognitive functioning. For instance, I'm not going to say for instance because that's coming up later in the training. Post-traumatic stress disorder is a mental health condition triggered by experiencing or witnessing a traumatic event. Its symptoms include flashbacks, severe anxiety, and uncontrollable thoughts about the event. And such accommodations may include flexible scheduling, a quiet workspace, or access to mental health support. Anxiety disorders. These include generalized anxiety, panic disorders, and social anxiety disorders. The symptoms may include excessive worry, relentlessness, and physical symptoms such as rapid heartbeat. Accommodations may include a modified meeting environment, options for remote participation, or stress reduction resources. Depression, a mood disorder that characterized by persistent feelings of sadness or a loss of interest. It can lead to fatigue, difficulty in concentrating, and disruption in daily functioning. Accommodations may include flexible deadlines, access to mental health services, or supportive environments. Then there are silent disabilities. These disabilities may not be immediately recognizable, but they can significantly impact an individual's ability to function effectively. There are learning disabilities such as dyslexia and dyscalculia. Such disorders affect the brain's ability to receive, process, and respond to information. It can cause difficulty in reading, writing, or mathematics, which can impact academic performance. Such accommodations may include extended time on testing or assessments, alternative formats for assignments or evaluations, and specialized tutoring or specialized assistance or advocacy in that process. ADHD, attention deficit hyperactive disorder, is a neurodevelopmental disorder characterized by inattention, hyperactivity, and impulsivity. Its effects can include challenges on maintaining focus, organizing tasks, or regulating impulses. Accommodations include breaks during tasks or evaluations, organizational aids during assessments or evaluations, or or demands by the agency, or reduced distractions in the environment. The sensory processing disorder is a condition where the brain has trouble receiving and responding to sensory information. Its effects include over or under reaction to sensory stimuli, leading to difficulties in various environments. Such accommodations may include sensory friendly spaces, noise canceling headphones, or visual aids. Chronic fatigue syndrome, CFS, is a complex disorder characterized by extreme fatigue that doesn't improve with rest. Its effects can include cognitive impairments, sleep disturbances, and muscle pain. Such accommodations include flexible hours to be able to attend evaluations and assessments, reduced workload or reduced stress under evaluations and assessments, and opportunities to rest. Fibromyalgia. Fibromyalgia is a condition characterized spread by musculoskeletal pain, fatigue, and tenderness. Its effect can be cognitive difficulties, often referred to as fibrofog, including problems with attention and memory. Accommodations may include flexibility with work tasks or evaluations or other demands, ergonomic modifications, such as a more comfortable seating or standing arrangement, and access to physical therapy or physical exercise or physical relief when they tend to get stressed and feel rigid. In a conclusion, recognizing both the visible and invisible disabilities is crucial for ensuring that individuals receive the necessary support and accommodations under ADA. Understanding these conditions can empower parents and advocates to advocate for appropriate resources and accommodations in various settings, including child protective services. Okay, now we move to reasonable accommodations in child welfare agency interactions. When parents with disabilities are involved with a child welfare agency, it is essential to ensure they receive appropriate accommodations to support their parenting abilities and participation in the process. The following are examples of reasonable accommodations: communication aids, providing access to interpreters, written materials in accessible formats, or other communication tools. The purpose is to ensure clear understanding of process and requirements. Modified meeting environments, such as conducting meetings in a quieter, less stressful, or maybe less authoritarian environment. The purpose is to reduce anxiety and facilitate better communication. Extended time for assessments, allowing additional time for assessments or evaluations. The purpose is to accommodate processing speed and reduce stress during evaluations. Access to support persons, allowing parents to bring a support person to meetings or assessments. And the purpose is to provide emotional support and assistance in understanding proceedings. Flexible scheduling, offering flexibility in meeting times to accommodate therapy and medical or other appointments. And the purpose is to ensure attendance and participation without added stress. Written summaries of meetings, providing written summaries or minutes from the meetings. And this is to help parents retain information discussed and understand the next steps. Breaks during meetings, allowing for breaks during long meetings or assessments. The purpose is to help manage anxiety and maintain focus. Training on available resources, providing education on available resources for mental health support and parenting skills. And the purpose is to empower parents with tools and knowledge for better parenting. Now, what are some of the reasonable accommodations in court proceedings? In the court setting, reasonable accommodations can help ensure that parents with mental health conditions are able to participate fully and effectively. And here's some examples. Real-time transcription services. Providing real-time transcriptions of court proceedings means that there is a court reporter who is sitting typing up the court proceedings, but the parent has, or the disabled person has, a screen sitting in front of them that they can see what the court reporter is actually typing. The purpose is to assist parents in following the proceedings, especially if they have processing difficulties. Questions for depositions, allowing questions to be submitted in writing prior to the depositions. And the purpose is to enable parents to prepare adequately and reduce anxiety during questioning. Breaks during court hearings, scheduling breaks during lengthy court sessions. The purpose is to allow parents time to regroup and manage stress. Visual aids and summaries. Using visual aids or providing written summaries of key points and decisions made in court. The purpose is to enhance understanding and retention of information. Assistance from court personnel, allowing court personnel to provide assistance in navigating the court process. Although we know there aren't many court personnel, court officers who will assist, but actually the courts should be providing a specific ADA advocate or support person. The purpose is to ensure that parents understand their rights and responsibilities. Access to mental health professionals. This is to provide access to mental health professionals during court proceedings. And the purpose is to offer immediate support if a parent feels overwhelmed with anxiety. Flexible testifying arrangements, allowing parents to testify via video or in a less formal setting. The purpose is to reduce anxiety and create a more comfortable environment. Clear information in court proceedings, providing clear and concise information on court procedures and expectations. The purpose is to help parents navigate the legal process with confidence. In conclusion, requesting reasonable accommodations is crucial for supporting parents with disabilities in child welfare agency interactions and court proceedings. Understanding and advocating for these accommodations can help ensure parents they are treated fairly and can effectively participate in decisions regarding their children. Now we're going to talk a bit about specialized courts. These are courts such as mental health courts and drug courts that have been established to provide tailored support and interaction for individuals facing specific challenges, including those with disabilities. Here is an overview of how those courts operate, and particularly regarding accommodations for parents with disabilities. Specialized courts for parents with disabilities. An overview of specialized courts. Specialized courts are designed to address the unique needs of specific populations. They aim to promote rehabilitation and support rather than punishment. Mental health courts provide individuals with mental health issues access to treatment and support instead of traditional punitive measures. And the key features are collaborative approaches involving judges, mental health professionals, and social services. They focus on treatment plans and ongoing support. There are regular check-ins and progress reviews. Drug courts address substance use disorders through treatment rather than incarceration. The key features are comprehensive assessments to identify needs, tailored substance abuse plans, regular monitoring and accountability, and often involve periodic drug testing. The purpose of me discussing these specialized courts for parents with disability, it needs to be where we move to. That these specialized courts, and of course they say every parent's crazy, so as far as I'm concerned, every parent falls into ADA and 504 accommodations. Okay, accommodations and supports for parents. Parents with disabilities involved in specialized courts might be able to receive various accommodations and support to help them successfully navigate the legal process and make positive changes in their lives. One, such as probationary periods with support services, offering a probationary period during which the parents can demonstrate their commitment to treatment and improvement. The purpose to allow parents time to stabilize in their conditions while maintaining parental rights. Access to treatment programs, facilitating access to mental health and substance abuse treatment programs as part of the court process to ensure parents are receiving the necessary support to address their challenges. Case management services, assigning case managers to assist parents in navigating services and resources. The purpose to provide guidance and support in accessing treatment, housing, and other necessary assistance. Now, I know most of you advocates, I'm not going to stop, but I know most of you advocates by now are probably saying, yes, Connie, wouldn't it be nice? Because they're supposed to be doing several of these things already. But the importance of going through these and the training on ADA is a separate and specialized law to protect people with disabilities. And as they continue to claim that parents are mentally incompetent to raise their children, we need to redirect these accommodations and supports under ADA and Section 504. A family-centered approach, emphasizing the importance of family connections and involvement in treatment plans to keep families together and support parents in maintaining relationships with their children. Flexible court scheduling, allowing adjustments to court dates and times to accommodate treatment schedules or other obligations. And the purpose is to reduce barriers to participate and comply. Education and support groups, providing access to parenting classes and support groups and educational resources that are not punitive. And the purpose is to enhance parenting skills and build a support network. Regular progress reviews, scheduling regular hearings to assess progress and adjust treatment plans as needed to keep the parents accountable while providing ongoing support. And utilization of mental health professionals, involving mental health professionals in court proceedings to provide assessments and recommendations. And the purpose is to ensure the court understands the specific needs of parents with mental health challenges. Now, I'm not done yet, but as I said, I know most of you who've had experience with CPS are saying to yourself, oh, Connie, oh, yes, wouldn't it be nice? And as we develop our training in ADA, we will talk about why they should be doing that and why they're not doing it, and how you can use ADA in Section 4 to basically put it in writing and put it before the court. I'm sorry, I've got a couple of you I just need to mute here. All right, now let's see. Family Center. All right, we talked about those. All right, the benefits of specialized courts for parents. Holistic approach. Of course, specialized courts would focus on the underlying issues. Oh my gosh, I go to Washington, D.C., and I talk to them all the time about underlying issues and precursor events, that these may affect parenting, leading to more effective interventions. Improved outcomes. By providing necessary support, specialized courts can lead to better outcomes for families, reducing the likelihood of recidivism and enhancing family stability. Empowerment. Parents are encouraged to take an active role in their treatment and care of their children, fostering a sense of agency and responsibility. And of course, because all the parents feel like they're in a punitive environment, that is something that's lacking throughout the whole course of CPS. The conclusion is specialized courts like mental health courts and drug courts play a vital role in supporting parents with disabilities. By offering tailored accommodations and focusing on rehabilitation, these courts can help parents address their challenges while maintaining parental rights and connections with their children. I know that there is at least one state that is basically doing like a drug court for parents. We do have in Tennessee and in several other states what is called a safe baby court. And there's actually a national organization called the Safe Baby Court, safebabies.com or .org or whatever. So that is a very specialized a place where they're really looking at mothers who have been using during illegal substances during the pregnancy. But we need to continue to take a broader scope of that, and as advocates and as ADA advocates, make sure that those requests and accommodation requests get put in writing and get filed with the court. Now, how do you address the failure to provide reasonable accommodations? So it is crucial for ensuring the rights of parents with disabilities to make sure that those rights are upheld. And below is an overview of potential consequences for the types of relief that can be sought, relevant legal precedents, and including one particular case of Tennessee v. Lane. Consequences of not providing accommodations. When an administrative agency or court system fails to provide necessary accommodations. It can lead to several negative outcomes for parents with disabilities. Of course, the increased stress and lack of accommodations can exacerbate their mental health issues, making it difficult for parents to participate effectively in the legal proceedings. The inability to present their case. Without necessary accommodations, parents may struggle to communicate their circumstances and needs, potentially leading to unfavorable outcomes in custody and support decisions, and a violation of civil rights. The failure to provide accommodations can constitute discrimination under ADA and Section 504 of the Rehabilitation Act, infringing upon an individual's civil rights. Now, I want to say, please understand, attorneys do not deal with ADA, because attorneys are not capable, nor do they have the patience, nor do they have the bandwidth to be able to see when they have what they consider a difficult client. They are not able to break down what is the disability of the client and what are the accommodations that need to be made. If we could make that occur, and if we can assist that to occur during this process and get it in the record that this needs to occur, basically under the threat of ADA, because there is no immunity for the state in ADA. So we have to make sure that we're always putting it out there. And unfortunately, some of the case law that we're getting on termination of parental rights is not very supportive. So we've got to push it quicker and as a precursor to anything else that happens. All right, and what is the relief for parents and advocates? So there are several avenues to seek relief when accommodations are not provided. So there are complaints. And as I showed you on the ada.gov site, there is a link to file a complaint. And in one of our previous trainings, we talked about complaints. So advocates, of course, are not attorneys, but they are advocates and they can assist with filing complaints. Or if they know of ADA violations, they can file complaints on behalf of somebody else. It is not a legal service. It is not legal representation to assist somebody in filing an official complaint. So the type of complaints are filing an internal complaint with the agency. So most agencies have an internal grievance procedure for addressing complaints about ADA and its accommodations. And the process is parents can file a written complaint detailing the lack of accommodation and its impact on their ability to participate. And that's why it's so important that we document this from the very beginning, because complaints are hard to do. It's hard to backtrack. It's hard to start trying to sort these things out after you're already deep into it. But if you start documenting it and start filing it and articulating it from the very beginning and what accommodations are requested, if you have to file a complaint, then you already have that information. Number 2, filing a complaint with the Office of Civil Rights, the OCR. Complaints can be filed with the OCR with the U.S. Department of Education or the Department of Health and Human Services. So the OCR is different from the DOJ. So with the DOJ, which is where we were looking at the ada.gov, you will file complaints with the Department of Justice as a civil rights violation, but you can also file with the Office of Civil Rights for the Department of Health and Human Services. The parents must submit the complaint alleging discrimination based on disability and request an investigation. And this obviously has worked in the past, so we don't want to snuff that or turn our heads on that. A legal action, if internal or administrative remedies are insufficient, parents may consider filing a lawsuit under the ADA or Section 504. The process is a civil complaint filed in state or federal court seeking injunctive relief, damages, or both. Now, we all know that requires a very smart and very aggressive attorney. Very difficult to file ADA as federal actions, but it can be done. And as I stated before, if it is a civil rights violation under ADA, if it is a constitutional right that is being violated, then there can be damages, and the state does not have immunity. And finally, the State Human Rights Commission is another area, is another place to go. Most of states, almost all states, have agencies that handle discrimination complaints, including those related to disability. So we can file it with the state human rights commissions as well. And I don't think I covered that in the complaints training. Parents can file a complaint with their state human rights commission, which may investigate and take action. And that investigation would ultimately be part of the Attorney General, although they probably have an internal investigation team to get it started. All right, so what is the impact on civil rights? The failure to provide reasonable accommodations can significantly affect civil rights of the litigant, leading to discriminatory practices. A pattern of failing to accommodate individuals with disabilities can be viewed as systemic discrimination, and the loss of parental rights. In severe cases, failure to accommodate can contribute to decisions that unjustly remove children from their parents, violating the civil rights to family integrity. And also, there's a distinction between an ADA violation that is or is not a constitutional right, which we will delve into later. All right, so there is one particular case that comes out of Tennessee, and it's Tennessee v. Lane. And the U.S. Supreme Court addressed the failure of the state court system to provide accommodations for individuals with disabilities. Now, this was actually a physical accommodation that needed to be made. This was a country courthouse in a small county in Tennessee. They did not have an elevator, and the person who needed to show up for court was physically disabled, and could not get up the stairs. So this disability was specifically, it was a visible disability. It was something in which there was a very specific accommodation that needed to be made, and it was not made. However, this particular case goes into a lot of discussion about disabilities and accommodations. The case involved a plaintiff who, due to a disability, was unable to access the courthouse stairs and was denied an opportunity to attend his own hearing. The Supreme Court ruled that Title II of the ADA applies to state courts, and that individuals have the right to access court services and proceedings. Now, the Tennessee court has already held that ADA does not apply to TPR proceeding. So we have to dig into and distinguish between whether or not the specific proceeding is entitled to ADA relief, or is it just the access to the courts? And we will going to talk about that more in follow-up trainings. The implications are the rulings emphasize that states must provide reasonable accommodations to ensure access to the judicial system for individuals with disabilities, and failure to do so can result in legal liability under ADA. Now, most of the court systems want to continue to argue that this is only physical access. They continue to say it's only physical access. And the courthouses will have an ADA coordinator that they will give you notice of, and they will talk about access to the court, but they don't talk about these other invisible disabilities. When accommodations are not provided to parents with disabilities, are entitled to seek relief through various channels, including internal complaints, federal investigations, and legal action. The case of Tennessee v. Lane serves as a critical reminder of the legal obligations of the court system to ensure accessibility and uphold the civil rights of individuals with disabilities. Okay, so now I know this is one of these brainy trainings, and I try not to talk too fast when we're going through it. All of this, everything I have said here is critically important. And what I'm going to create out of this is a one-page fact sheet and basically a checklist to be able to go through with parents to see if their disability requires any additional accommodations that needs to be put into the record at the very commencement of their case or their dealings with CPS. Now, here are some things that we still need to cover in ADA. So, how is a disability recognized in the court system? And I'm going to give you a little bit of a spoiler alert here because a disability does not have to be diagnosed. I know a lot of the things that we have talked about today require or seem to require a diagnosis, such as PTSD or ADHD. But to qualify for a disability under ADA, all it requires is that you have been held out to be a disabled person or treated as though you have a disability. Again, most parents are treated with stating that they are mentally incompetent to parent. And I know on a recent parent, they filed a termination of parental rights, and they said that they have failed to remedy the mental health problems that cause the removal of the children, which immediately triggers ADA. Using the ADA for children caught in the system as well as parents. We don't really talk about here, although some of the same things that will apply. However, for children, they have the additional disadvantage of being put in the homes of strangers who are required to attend to their medical, physical, mental health, and emotional needs. Any child that has been removed from a parent, I think, should be considered to have trauma. And so they need to address that trauma along with any other physical or psychological needs, and that does not include medicating them. All right, now Sarah Gordon, I mentioned this at the beginning. This technical guidance that was put out by the Department of Justice and HHS arises out of the Sarah Gordon case in Massachusetts. And so we'll look at how does the Sarah Gordon case, and we'll talk about how does it affect child welfare cases today. I will tell you, in Tennessee, they like to say that the Sarah Gordon case does not apply. And then how do the courts ignore ADA in termination of parental rights cases? And do agencies and courts maintain immunity in ADA violations? Whew, oh, you all have been so patient today, and I am going to stop the recording so that we have a clean training and then open the floor up for some questions. We will download this, upload it to YouTube, and then also I'll set up my Google Classroom. If you've been paying attention and if you've kept up with us, the last training was a training where we talked about the Washington trip, where we also had some other people who came to Washington join us. I have downloaded that. I'm not sure if I've got that uploaded yet, but I did get it downloaded from Zoom. So y'all have to be patient with me a little bit. A lot of things are going on. I have a lot of things I'm responding to. I'm watching things all over the place. I'm particularly paying attention to Washington these days, as well as state legislators that are getting back on track, and several things are happening at the state legislative level across the board. Please watch your state and see what is going on in your legislature. It's very, very important that we identify empathetic legislators at the state level. What we are finding, I have here in Tennessee, I have probably a half a dozen empathetic state legislators, but they cannot carry the day. And the other legislators continue to be influenced by money and lobbyists and the narrative that parents are bad laws, etc., you name it. So please pay attention. If you see a law come up in your state that seems to be protecting parents, pop it up, take a look at it, share it with me in Messenger. I'm trying to save these links, and then we will and make a note about who that state legislator is so that we can create a little army of empathetic legislators all across the country. And maybe that will also help us get the federal legislation that we need. All right, hang on, and I am unrecording.